Welcome to Chapter 2 of the Digital Personal Data Protection Act 2023. In this chapter, Scope and Application of the DPDP Act, we explore the core principles defining the Act's application, the roles of key entities like data fiduciaries and data processors, exemptions for national security, legal compliance. The Digital Personal Data Protection Act 2023, DPDP Act, is a crucial piece of legislation that governs the collection, processing, and management of personal data in India. This chapter delves into the scope and application of the Act, including the parties it applies to, the territorial jurisdiction of its provisions, and the exemptions and exclusions that it provides. Who does the Act apply to? The DPDP Act applies to various entities involved in the processing of personal data, and it categorizes them into data fiduciaries and data processors. Both categories play distinct roles within the data processing ecosystem and are subject to specific obligations under the Act. Data fiduciaries, Section 2. A data fiduciary is any person or entity that determines the purpose and means of processing personal data. Essentially, data fiduciaries act as the data controllers in the data protection ecosystem. They decide what data is collected, how it is used, and why it is processed. Data fiduciaries are held accountable for ensuring that the processing of personal data is done in compliance with the DPDP Act's provisions. Key responsibilities of data fiduciaries: obtaining consent. Data fiduciaries must obtain explicit consent from the data principal, the individual whose data is being processed, before collecting or processing their personal data. Transparency. Data fiduciaries must maintain transparency regarding the data processing activities by informing the data principal about the types of data collected, the purpose of processing, and the rights of the data principal. Data security. They are required to implement appropriate technical and organizational measures to protect the security and confidentiality of personal data. Accountability. Data fiduciaries must ensure that any third-party service providers, such as data processors, comply with the DPDP Act. Example: a telemedicine platform that collects and processes personal health data of patients is considered a data fiduciary because it determines the purposes, providing medical consultation, and the means, collecting personal data via a mobile app, of processing that data. Data processors, Section 2. A data processor is an entity or individual that processes personal data on behalf of a data fiduciary. Unlike a data fiduciary, a data processor does not make decisions about the data or its processing, but acts strictly under the instructions provided by the data fiduciary. Key responsibilities of data processors: acting on instructions. Data processors are required to process personal data strictly according to the instructions provided by the data fiduciary. Data security. They must implement adequate security measures to protect personal data. Compliance with agreements. Data processors must enter into formal agreements with data fiduciaries, specifying the terms and conditions under which personal data is processed. Example: a cloud service provider that hosts personal data for an e-commerce company is considered a data processor. The service provider does not control how the data is used, but is responsible for securely storing and processing the data as per the contract with the e-commerce company, the data fiduciary. Territorial jurisdiction of the Act. The DPDP Act applies to personal data processed both within India and, in certain circumstances, outside India. The Act's provisions extend beyond India's borders to ensure that personal data related to Indian citizens is protected, regardless of where the processing takes place. Processing of personal data within India, Section 3. The primary jurisdiction of the DPDP Act applies to the processing of personal data within Indian territory, regardless of the location of the data fiduciary or data processor. If personal data is collected or processed within India, the DPDP Act applies even if the data is subsequently stored or processed outside India. Example: if an Indian telecom company, data fiduciary, collects the personal data of Indian citizens, processes it on servers within India, and stores it in a data center within India, the DPDP Act applies to this data processing activity, regardless of whether the telecom company has its headquarters abroad. Processing of personal data outside India, Section 3. The DPDP Act also extends its jurisdiction to entities outside India under certain conditions. Specifically, if the personal data processing is related to activities such as offering goods or services to data principals, individuals in India, or monitoring the behavior of individuals in India, the provisions of the DPDP Act will apply to foreign entities. Example, a US-based e-commerce company processing the personal data of Indian consumers, even though the data processing takes place in the US, will be subject to the DPDP Act provisions if the company is offering goods or services to data principals, Indian citizens, in India. Exemptions and exclusions. While the DPDP Act aims to provide comprehensive data protection, it also includes certain exemptions and exclusions. These exemptions are primarily intended to balance privacy protection with other societal, governmental, or business needs. Exemptions. Related to national security, Section 17. The DPDP Act allows exemptions for the processing of personal data when it is necessary for national security, public safety, or for the prevention of crime. Examples: national security exemption. The central government may authorize the processing of personal data by intelligence agencies or law enforcement agencies even if it violates the provisions of the DPDP Act when it is deemed necessary for national security purposes. Example: personal data may be processed by security agencies for the investigation of terrorist activities or cybercrimes, without necessarily adhering to all provisions of the DPDP Act. Exemptions for legal obligations, Section 17. Exemptions are also granted when the processing of personal data is required to comply with legal obligations or a court order. Example: a financial institution may be required by law to retain and process certain personal data of its clients to comply with Know Your Customer (KYC) regulations. Personal and domestic use, Section 3. The DPDP Act does not apply to personal data processed for personal or domestic purposes. Personal data processed by individuals for personal activities, such as sharing on social media, is exempt from the Act's provisions. Example: if an individual shares personal data, e.g. photos or opinions, on social media, the DPDP Act does not regulate this data processing, as it is for personal use, not for commercial purposes. Exemptions for processing in the public interest, Section 17. The Act also allows exemptions for data processing in certain circumstances where it serves the public interest, such as for scientific research, statistical analysis, or historical research. However, the data must be anonymized or pseudonymized to prevent identification of individuals, and ethical standards must be maintained. Example: data collected during a public health research project may be processed without individual consent, provided the data is anonymized or pseudonymized, ensuring individuals cannot be identified. Key takeaways. Who the Act applies to. The DPDP Act applies to both data fiduciaries and data processors who have distinct responsibilities regarding the processing of personal data. Territorial scope. The Act applies to data processing activities both within India and by foreign entities processing personal data related to Indian citizens. Exemptions and exclusions. Certain exemptions apply, including for national security, legal compliance, personal use, and public interest activities, but safeguards and restrictions must still be adhered to. In the next chapter, we will explore the rights of data principals under the DPDP Act, including their right to access, correct, and delete personal data. This chapter provided a detailed understanding of the scope and application of the DPDP Act, laying the foundation for exploring the rights and obligations of individuals and organizations involved in personal data processing. Thank you for joining this session. In the next lesson, we will explore the definitions under the DPDP Act, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session.